we'll just kind of quickly get into the right mindset for today's discussion. As you all know, our topic here today is using deposition testimony at summary judgment. So let's frame this for you. You've litigated a case for years. The depositions are over. You have a pile of transcripts. You have a pile of exhibits. You're literally just drowning in paper. It's up to your chin. What's the next step? What do you do from there? And we want to tell you all, don't despair about that. Today, we're going to discuss what to do in that situation in our program using deposition testimony at summary judgment. This is episode 2 of the Financial Poise series on doing depositions. You can read more about financial poise in slide 2. I'll try to advance the slides as we go along here this afternoon. I want to give our panelists each a chance to introduce himself. And so, Rich, we'll start with you.
Depending on your time zone, good morning or good afternoon. My name is Rich Hellerman. I am a sole practitioner. I have been practicing for 38 years, give or take, and I've been solo for 12 of those years. And it's a pleasure to be here with you, Seth, and Max and Matt as well.
Thank you, Rich. Appreciate that. Matt, next up, I'll give you a chance to introduce yourself.
I'm Matt Christensen, practiced in Boise, Idaho. That's where I practiced my whole career, which is about 20 years this coming September, mostly in the federal courts and bankruptcy courts in Idaho.
Very good. Thanks, Matt. And Max, you're up. You can feel free to introduce yourself.
Sure. Hi, my name is Max Stein. I'm with Max and Mago and Macaulay here in Chicago. I do general commercial litigation. I often say I'm a true commercial litigator, having done things from the smallest of cases to large securities fraud cases that went on for many years and included many deposition transcripts.
Thank you all for your introductions. My name is Seth Horvath. I'm with the law firm Nixon Peabody. I'm a general commercial litigation attorney. I've been doing this for over 20 years and really enthusiastic to talk with the panelists today about our topic. If you want to see a bit more about our backgrounds and information about us, you can read our bios. They're at the back end of the slide presentation. That's going to be on the later slides that we'll get up to as we move forward here today. About the slides, I kind of mentioned this already. I'm going to try to call attention to the slides that are relevant to whatever we're talking about so that you as the audience can take notes if you like and keep up with the flow of the discussion. But don't worry if you're just listening to this program and you're not watching it. You'll be fine. The slides are not critical. They're there for guidance. It's the content of the discussion that we want to focus you on and that we hope you find useful. Thank you to our co-producer of the program as we start off, the National Law Review. You can read more about the National Law Review on slide number 3. And the last thing before we get started on the substance, slide 4 has a disclaimer on it. And that disclaimer just says that you are not our clients. We are not your lawyers. What we're doing here today is for your general education, not for you to act on without appropriate advice. So we appreciate your participation today and look forward to getting through our panel topics. And without further delay, off we go. So I want to start the discussion and kind of get folks oriented by asking each of you the same initial question. And we'll start with Rich, and then we'll go to Matt, and then we'll go to Max. But the question is, drawing on your experience with summary judgment motions, can you share any examples of a case where a particular deposition or depositions had important implications for summary judgment? And Rich, I'll let you start off on this one.
Sure. And thanks, Seth. I hate to start out by giving a more general rather than a more specific answer, but I have to say depositions, of course, a critical point in a case, critical tool for any litigator. But I caution especially young litigators, in thinking that you're going to go with your opponent and hit a home run, and it's going to become a television showcase where, just as at trial, where they fall to their knees and just admit everything, that you're going to get that in deposition, much less at trial. So be careful is my point about that. But with that said, summary judgment and depositions go hand in hand, because you're going to be putting into your brief citations to moments in what could be a 3, or in federal court, a 6 or 7 hour deposition, where your opponent or even witnesses who aren't the parties but who have knowledge are going to give you nuggets. And that's kind of how I look at depositions in summary judgment context. You're going to get a couple of nuggets from each witness if you're lucky, and you use those to make your case that, hey, the witnesses here line up, the facts line up, they're not disputed, and this is why on a motion, you, judge, should grant us summary judgment. I had a case just recently, so it's actually pre-summary judgment phase. But I will tell you that the plaintiff, I represent some defendants, he acted in a way in the course of the case as though there was no agreement between the parties. When they offered him things, he took it, but it wasn't pursuant to any agreements. Now he's contending there was an agreement. And in his deposition, he said, you got to understand, there was a gentleman's agreement here. And I said, well, was that ever committed to writing? You're not getting the point here. And he kept on harping on the fact that there was this agreement as men, and they knew one another. And as honorable men, we had terms. I can't wait to use that on summary judgment, because the answer to the question was no, there was no agreement. So that's to be decided, and maybe in a year we'll come back and we'll see how my motion went. But that's my most recent semi-war story about depositions for summary judgment.
That is a great example. I think it kind of really draws a nice picture of how deposition testimony can come to life to be used later. I also appreciate your comment about how it's rare you're going to get a Matlock moment at a deposition where the witness just decides to lie down and give you everything you're asking for. So appreciate that context, Rich. And I'll turn over to Matt with the same question. Matt, just looking for any examples or wisdom you can share about cases where a deposition or depositions had some importance for you or your client.
I'll first sort of echo one of the comments that Richard made, which is that usually when I approach depositions, I'm not necessarily doing the deposition with the intention of following it up with a summary judgment motion. A lot of times it just sort of falls in your lap that, hey, this is the testimony they gave. Well, shoot, now we got a good summary judgment motion we can file. And then the sort of war story example I want to give is sort of a negative implication of depositions. We had a case where we represented the defendants, and plaintiffs filed a case that on its face did not meet the elements of the claim that they were trying to pursue. And so we filed a motion for judgment on the pleadings, said, look, judge, they haven't even led facts that meet the requirements. And their response was basically, well, we need to do some discovery and then we'll be able to, we'll start the facts. And the judge bought that and gave them time to do discovery, one of which was the depositions. So they deposed our clients, we deposed them, and then we filed virtually the exact same motion, but as a summary judgment motion now instead of a motion for judgment on the pleadings. And they got absolutely nothing out of the deposition that established any of the facts that we said don't exist in the case. And so after the summary judgment motion was filed, then the judge was like, okay, you had your chance and still couldn't produce the facts. So we'll go ahead and grant the motion at that point. So that's more a negative story where, you may get the chance to bury yourself with the deposition. And if you're given that opportunity, maybe you shouldn't actually take it.
It's a cautionary tale of be careful what you ask for when you think you're going to have a wonderful experience in deposing someone and doesn't quite work out that way. And thanks, Matt, for sharing that one. And Max, I'll turn this initial question over to you. And if you could share with us any examples you have of cases where a deposition or depositions were significant in summary judgment. We're interested to hear your thoughts.
Sure. So I think it's actually going to depend a fair amount on the types of cases you're handling. For me, much like what Matt said, I don't generally go into a deposition expecting there will be a motion for summary judgment in the case. My wife, on the other hand, is an employment defense lawyer. And so for her practice, nearly every case gets decided. In nearly every case, there is a motion for summary judgment. And so when she and her colleagues are going into depositions, they are absolutely expecting there will be a motion for summary judgment. And so they actually might go about the deposition in a different manner than I might go about it. I'm, like Rich said, looking for those nuggets, trying to find the nuggets. And then when I get them, letting them all build up together. And for other people, they very well may be looking for the actual testimony that is going to end the case and expecting that they will get it because that's the kinds of cases they're dealing with. So I think it really does depend a little bit on the types of cases you're handling. And so if you're a lawyer, if you're a younger lawyer who's thinking what we're saying about these depositions doesn't make sense, it's possible that that's because of the kinds of cases you're handling, and your colleague down the hall who's handling a different type of case is nodding along with us while you're looking at us quizzically.
That's a great point in terms of framing how this is going to be context dependent, and I suspect our audience is going to hear a lot of that as we work through the rest of our Q&A today. I mean, some of these questions and the answers are just going to depend on the circumstances of a particular case, and that's kind of the nature of litigation. And with that in mind, kind of on the same topic, Rich, I'll put the question to you. As an attorney taking a deposition, what are some of the considerations that are in your mind about summary judgment in connection with taking a deposition, recognizing, as we've been talking about, that the context is really going to dictate whether you think a summary judgment motion is likely to be appropriate in the case? What are some things you think about in that regard when you're preparing to take someone's deposition?
Well, good question. And first and foremost, whose side am I on? Am I a plaintiff or am I a defendant? The notion as a plaintiff in most cases, unless, as Matt and Max have alluded to, you get something that is just dropped in your lap, straight from heaven to the witness's mouth to your lap, where you get something that you weren't expecting. I'll say, general rule, as a plaintiff, even in commercial disputes, really hard to expect that you're going to have a summary judgment case. You've got the burden of proof. The bar is so low for a defendant in any claim. And certainly if you're getting into some heavy commercial litigation like fraud and breach of fiduciary duty, where burdens of proof may be higher, clear and convincing, things like that. The idea that you might be thinking about summary judgment as a plaintiff in a case like that, I think you're deluding yourself in all but the most egregious case. So with that said, if you are a defendant, on the other hand, you're trying to, I think you need to familiarize yourself, if you aren't already, with all of the elements of your claim and know that every witness does not necessarily go to every element. So you really want to focus your attention with each witness on what am I deposing this person for? Very few witnesses are across the board, everything and anything. So if you have a causation witness or if you have a damage witness, focus on that. Do your due diligence in preparation, and again, try to lock them in on 1 or 2 or 5 discrete points that may be in conjunction with other witnesses or documentary evidence. Maybe if they're good enough or if they're big enough of a witness on their own, if you can get them to just concede, or if not fully concede, get them in a place where they can't get away from a certain fact that's helpful to you in any one of those elements. You've done a good day's work, and tag that in your file for later for the summary judgment motion.
I kind of like your thought process on this, Rich, and I think it's useful to share that thought process with the audience, and that you can all tell that what Rich is saying here is you want to be thoughtful about how you approach a deposition. And yeah, the context is going to vary, and the facts are going to be specific to a particular case, and it depends on what side you're on, but you want to give it some forethought. And I'm going to ask kind of a flip side of the same question to Matt, and this is with respect to defending a deposition. Again, recognizing that a lot of this is going to be context specific. Matt, I was wondering if you could share with our audience what are some of the considerations that you give to summary judgment when you are defending someone in a deposition or preparing to defend someone in a deposition?
So defending a deposition is always a lot different than taking the deposition. I'm not trying to get information out of that person necessarily. I may have to clarify something he says or something along those lines. But generally, my work in defending a deposition comes before the deposition in meeting with, I'm assuming it's my client or my client's representative that's being deposed. And so I'm meeting with that person and preparing them for the deposition. So from a summary judgment context, I'm looking at, okay, what are the chances the other party is trying to set things up for summary judgment? What are the elements of those claims, and where's the weaknesses that we have in some of those elements? Because if the other side's doing their job right, they're targeting those weaknesses and trying to exploit them in the deposition. And so I've got to be able to recognize them on our side, and get my client prepared for the types of questions that may get asked of them on those issues. As we've sat here, I thought of a different example that I could have given at the beginning, I guess, but we had a fraudulent transfer claim case once that we were pursuing. There was about 30 different pieces of real property that had been, in our view, fraudulently transferred by these defendants. And they had, prior to implementing this plan, which in all of our pleadings we called it a scheme, and when the judge started calling it a scheme, we knew we had won the case. So before engaging in this, they had met with an asset protection attorney who had drafted like a proposed plan for these two brothers. And in that document, there's a part where he describes the plan as an onion. And there's going to be so many layers between your assets and all the creditors that are coming after you that they're just going to run away crying because the onion's too deep and hard for them to get to the assets. And so at the deposition of the brothers, we pulled that document out and said, look, this is what you were trying to do, right? It says it right here in your plan. Now, if the attorney defending the case very clearly had not prepared his client for that document even being an exhibit, and because their answer was, yeah, that's exactly what we were trying to do. And then shortly after that, we settled the case and they gave us virtually everything we asked for.
Sure.
So you've got to recognize where the holes in your defense are or where the weaknesses are, and prepare your client to not admit liability at that deposition.
I would just add to that. One of the things that I often, and apropos of both the answers that Rich and Matt gave, one of the things I often tell my witnesses is we are not going to win this case based on your deposition testimony, but
Right.
we might lose it based on your deposition testimony.
Yep. No doubt.
Those are wise words, and I share those words with folks as well, because I think they are true. And Max, that brings me along to more of a kind of operational question for you. We have a sense now of how you all approach depositions on both sides and what goes into your overall approach with respect to summary judgment. I wanted to get into a more granular topic. Do you have any pointers, Max, on how to keep track of testimony so that it's accessible once the time comes to file a motion for summary judgment? Anything you can offer up to help people go through that process of keeping things orderly during the deposition process?
Sure. So I'm going to answer the question in two ways, one of which involves the actual deposition. And that is, at the actual deposition, if you get one of those nuggets that Rich talked about at the beginning, if you get one of those nuggets, you need to ask yourself, how good was that nugget? How clean was that testimony? And if you think you got it cleanly, you might say to yourself, all right, I got it cleanly. I'm going to leave it alone so that nobody focuses on what I think is a very good nugget. You might also, though, decide you didn't get it as cleanly as you wanted to, or that you might want to try to gild the lily a little bit. And so what you might do is you might go back over that testimony. You might do it in a more cross-examination kind of style, as opposed to a deposition open-ended kind of style, and say, I just want to make sure I understood what your testimony was. I heard you to say that as you approached the intersection, you applied the brakes. I heard you say you saw the stop sign. I heard you say you came to a complete stop at the stop sign. And I heard you say that only after you were at a complete stop did you then proceed through the intersection. Is that right? And you would get them to say yes to each one of those points. And that way you have the nugget in a very clear, easy to pull out sequence that one of the partners I worked for as a young attorney called making pages. So you're just asking the questions, you already know the answers, and you're making the pages for purposes of summary judgment or potentially impeachment at trial. So that's one way to do it, and that's a way to do it while you're at the deposition. Then, after you get the transcript, candidly, there are any number of ways to do it, and they are changing constantly. And they're especially changing right now, where just about every legal tech offer email you get involves AI and the possibility of using AI to summarize deposition transcripts, otherwise summarize things. So there are any number of ways to do it. My biggest point would be figure out the way that works for you and try to do it. So one of the hardest things, you need to have a little bit of discipline and rigor here. But one of the hardest things to do is right after the deposition, you sort of have that adrenaline leave your body, take a little bit of time and summarize what you think you got out of that deposition. Because if you do that at that moment, then you can take that summary, you can compare it to the transcript when you get the transcript in about 10, 20, 30 days, and you can make sure that you got what you thought you had, and you can save that either in a PDF that you've highlighted, in a database program that keeps all of your deposition transcripts, in a Word file that you pull stuff out of and put in. Whatever it is that you do, have a system and try to use that system and try to stick to that system so that when you get to the point that Seth introduced at the very beginning, that mountain of paper, you actually have one piece of paper or one document that summarizes the mountain and helps you figure out where at least to start.
I think those are all great points, Max. And I guess the bottom line is you have to have a process in place. It's good to have a process. You need to be thoughtful about it. You need to try to keep track of all that testimony you're eliciting so you can do something with it. I'm going to kind of pivot back to one of the first things Max was saying in response to that question. And Rich, I'll ask this to you. Max was talking a little bit about things to do during a deposition to elicit testimony that can then be useful. And I'll ask you the question this way, Rich. We've all had experiences where we hear something in a deposition, or we think we hear something and we read it later and it turns out it's different from what we heard. What are some things you do in the moment to make sure your record is clear and can be used during summary judgment, whether you're on the defending side or the moving side?
First thing you do, pay attention. And I have an anecdote about that from when I was I think a second year associate. Before I went solo, I was at one firm for 24 years. And that firm represented a large retailer. And so we who were in litigation, had a lot of time to work on our skills in slip and fall cases or trip and fall cases or product liability cases from the products that the consumers would be purchasing and then cutting their fingers off or toes off with. And the firm had been doing this for so many years that they created what they called a cookbook. And all the young lawyers who were litigators got a copy of the cookbook. And the cookbook had the standard form interrogatories for a personal injury case, for a death case, for a survival case, for all these different types of cases that arise out of PI. And there were also outlines for depositions, the deposition of a plaintiff or a representative of a dead plaintiff, things like that. And I took a deposition probably as a second or third year, it was maybe my fifth or sixth deposition ever. And the partner who supervised me, who was a huge mentor to me in my career, he took it upon himself to review my transcript. And he said, you did a fine job, but the case is not going to rise and fall on this deposition. So you're safe there. You're not getting fired tomorrow because you screwed something up. But what he did say to me, and I've never forgotten this, is I could tell that you were at times going through the cookbook that we provided to you and asking question after question after question. And I could tell that you weren't necessarily listening closely to the answer. And to me, that was gold, that bit of advice, because there are so many things that can, not always, can come out of just listening to the answer rather than focusing on your next question. And frankly, it's kind of a piece of advice for life and for being a decent conversationalist anyway, even though deps are not conversations. We can talk about that later. But if you listen, something may jump out from the witness's mouth right to your head. And you, oh, I got to follow up on that right now because I may be taking him, or he may be taking himself to a place that neither of us thought he would be going. And that's going to be helpful to me. So pay attention and listen. Number one.
I
Number
think,
two. Go ahead. Go ahead.
I was just going to say, I think a theme that's emerging here is we can't plan everything that we're going to get out of a deposition and then plug it into a motion later. So
That's right.
there's a lot of being in the moment that factors into this. And go ahead, Rich. I didn't mean to cut you off. I
That's
just
right.
wanted to kind of
No,
sum up.
I think Max hit it on the head when he said, if you're not sure that it came out, whether it's because the words weren't great from the witness or because the lawyer, whose job on the other side is oftentimes to screw up the transcript and have it be, on the written transcript question that ends in ... and then an answer or an interruption by the lawyer. And then good luck trying to read that in as either an admission or as impeachment. So I think the phrase that Max said is exactly the phrase that I would use and that I have used hundreds of times, which is, I just want to make sure I understand your testimony. And you don't look like you're setting the trap. You look like you're just trying to understand the witness. And on both sides of it, when I'm producing a witness, one of the things I prep with is, this is not a conversation. Don't fall into the trap of a rhythm of question, answer, because then you're talking. It's not a talk, it's a question and answer session. Make the questioner do the work. Give them a responsive answer and as little as possible in that answer. On the other side of it, I like to try to be personable to a witness to make them think that it's a conversation and chit chat with me. And let's keep talking about this, buddy. And then you find some things that pop out.
Yeah, I will say I've gone so far as to, at the beginning of depositions that I am taking, I actually tell the witness that this is going to be the most awkward thing ever. And I tell that to them so that basically I'm like, look, I get it. This is weird. You and I are doing something weird, but we're going to do it together and we're going to try to get through it. And I have found that even just saying that will help get the witness more comfortable, more relaxed, and therefore a better witness for my purposes at telling me the things that I need to hear or find out from them, just by acknowledging. I mean, again, this is a lot about, Rich's point about listening, which was made to me by a mentor. And so I guess we're also advocating for good mentoring here. My first deposition, the first break, the senior partner who was with me pulled me out in the hall and he said, "So how do you think it's going?" I was like, "I think it's going pretty well." And he was like, "So what has he told you?" And I said 3 things. He's like, "And what did you do to follow up?" And I said, "Oh, nothing."
Yep.
Right. And he literally said to me, "It's not a conversation." So again, all of this is to say, you got to be in the moment and dealing with what's going on in the moment and do your best to maximize your opportunities in those moments.
Agreed. Very, very important thing to keep in mind is you're taking a deposition and certain things are just going to happen and you have to react in the moment. I will turn the conversation briefly over to a more technical point, and we wanted to talk a bit for our audience about the interplay between deposition testimony and affidavits. It's something that comes up from time to time, and I'm going to put this question to Matt. And Matt, I'll go about it this way. Let's assume you need testimony from a witness that you're in control of to support or to oppose a motion for summary judgment. Do you think you're better off eliciting that testimony during the witness's deposition or holding on to it and having the witness sign an affidavit at some later point in time? I was hoping you could walk us through some of the considerations that go through your mind in addressing that type of scenario.
So I'm going to continue the theme of pay attention as the deposition is going, right? because there's no duty for me to present testimony from my own witness in a deposition in order to use it on a summary judgment motion. I can do it by affidavit or declaration. But I need to pay attention in the deposition to see if he's saying something that's potentially different or contradictory to what I need him to say in the declaration later. And if that's the case, and they do, or if there's some sort of question of, maybe he is going off of what I need him to say later, then I would ask questions at the deposition and clarify some of that testimony. Just because if I submit a declaration later that potentially contradicts what he said at the deposition, then I'm opening myself to a motion to strike the declaration or a sham affidavit motion, that sort of thing. So, but if, whatever I need him to testify about doesn't even come up at the deposition, the deposition's not the start and end to the testimony that's allowed from that witness. So I can save it and just do the deposition later. So as we've said with just about everything, pay attention to what's happening in the deposition and run with it. I think importantly too, I guess, if I am going to need to ask that witness questions, that they need to be ready. And so I may want to have at least a conversation with them ahead of time that says, look, I don't plan on asking you any questions, but we are planning this summary judgment motion, and I'm going to need testimony about this. So if that issue comes up, I may ask some follow-up questions just to clarify things. So that they're at least thinking about that issue before we go into the deposition.
And I appreciate that last point, Matt. You kind of anticipated my follow-up question is, what do you have to do if you want to have someone testify in the moment? You got to prepare them. You got to make sure that's something that's going to be feasible in the context that you're dealing with. And I'm going to flip this question a little bit about affidavits, and I'm going to give this version of it to Max. And instead of focusing on a witness that you control, I want to talk for a moment, Max, about a third-party witness. Slightly different scenario. Let's assume you need testimony from a third-party witness to support or to oppose a motion for summary judgment. Are you better off eliciting that testimony during the witness's deposition or waiting to have the witness sign an affidavit? What are some of the considerations that factor into your analysis of that scenario?
Yeah, so basically the question boils down to how much control and how much cooperation do you have over that third-party witness? So one of the key points is you can't necessarily compel a third party to sign an affidavit if that's how you think you want to do it. You can compel them, hopefully, to sit at a deposition. And so that might actually be the consideration that answers the question. If that's not the consideration that answers the question and you have somebody who is willing to cooperate, then what I think you need to ask yourself is, how sure are you of their cooperation? Because if you get that affidavit sooner rather than later, you probably need to produce that affidavit, which might cause the other side to want to depose that person. If you get it later, then, or if you decide, well, no, I'm going to wait and I'll get it later, closer to summary judgment, the witness, something might change. The witness might no longer be willing to cooperate. The witness might no longer be reachable. Who knows what the issue might be? You might lose the ability. So you got to balance all of these considerations. And then the last thing I think you got to balance is there's a level of credibility. And this circles back to some of the things that Matt was talking about as well. There are basically three ways you can get sworn testimony that you can use in summary judgment. One is at a deposition, either during the other side's questioning of a witness or during your questioning of a witness. And then the third is through an affidavit. And if you ask me, if I have control over the witness, the best way for me to get sworn testimony is when the other side is questioning that witness. Because when that witness, who's been well prepared and gives an answer that is helpful to our case, under questioning by the other side, it's very hard to question like how that came about, why that is. It's most likely that that's the truth and the story they're telling is exactly what happened. Second, I would say, in terms of the best ways to get this testimony, is going to be through an affidavit because you have the control over the circumstances. And the third way is through my own questioning of my witness or a third-party witness who is cooperating with me. And circling back to the last point that Matt made, it is amazing how many times you will have talked with a witness during prep about a key issue, explain to them what you think how the key issue should go. They get asked a question that sort of glances near the key question. They get it a little bit wrong. And you decide, all right, I'm going to ask 5 very simple questions. We've gone over this in prep, and we're going to quickly clean this up. And you ask that first question, usually after your witness has been testifying for hours, and they're kind of like exhausted, understandably. They suddenly are now being questioned by their lawyer. So they're like, oh, everything's okay. I can relax a little bit. And you ask a question and they have no idea what you're talking about. Or worse yet, they completely mess up what they've said before 100 times. And so I would caution anybody asking their own witness questions to think twice, maybe 3 times, maybe 10 times before you actually do it, because it is remarkable how many times the witness does not give you the testimony you're thinking you're going to get, even though you've heard them give that very same testimony multiple times, made those statements countless times, because that is exactly what happened. But in the moment, at the deposition, when you ask the question, you don't get the answer you're looking for.
I want to chime in. I think this is an important point. I think as attorneys, a lot of times we get very comfortable with the litigation process and depositions and trials and sitting in a courtroom. And we sometimes forget that for a lot of our clients, they've never been deposed before, much less sat and gave testimony in a courtroom. And so they walk into that conference room and there's a court reporter there and everything's on the record, and there's the party that they hate sitting across the table from them, and that attorney sitting there, and everything that's in their head goes right out the door, right? And we forget that sometimes, which I think is to Max's point. You know, we have a friend that works at a large corporation that she frequently sits as a 30B6 deponent for that company because of the role she has. And she recently discovered that's a resume item for her, is that she's an experienced 30B6 deponent. Just because of that experience makes her more comfortable in that environment. And I think that's something that we forget, is what, you know, everyday people getting thrust into that environment, you know, the fear that they have being there.
Yeah, and again, just a great thing to be aware of is you're in the moment, again, returning to that theme, trying to understand how people are going to respond in that moment, and make sure you as the attorney have a sense of how the moment may play out months down the line when you try to use the moment to your advantage in a motion or in opposition to a motion. So I appreciate everyone's thoughts on some of these technicalities, and I do want us to have a moment to talk about errata, but I'm going to push the ball forward before we do that. I want to start talking about using deposition testimony to move for summary judgment and some of the technicalities associated with that, and some of the best practices and some of the things that you all do in that regard. And I'm gonna give Rich this next question. This is an in the weeds question of sorts, but it's an important one because we all have to present these motions to a court at some point, and a court or a decision maker has to digest what we're giving them. Any preference, Rich, when you're trying to digest all that testimony you have, between giving the court full transcripts versus giving the court excerpts of transcripts when you're trying to boil things down and file a motion for summary judgment?
I think you have to play responsive on that one, because the first and foremost consideration is, what does the standing order require from the individual judge? And that may change within a district. It may change within a county. Some judges want everything, some judges don't. And you know, you don't have to, but I find myself, you know, sometimes playing psychologist about, well, what's it going to look like if I do? What's it going to look like if I don't? In other words, if I give within a paragraph, I don't even separate out even a block quote that's indented of 2-3 sentences, but if I just use half a sentence in the midst of a paragraph that I'm writing, my first thought, if I'm reading that from the other side, whom I don't trust reflexively, is, what are they hiding? They didn't even give me one sentence from this witness. So then when I'm doing that, it's like, well, if I were me against me, what would I think about me as me? So you end up kind of doing some calisthenics in your head about what seems the most credible. Because to me, for summary judgment in particular, even if you're filing it strategically, not expecting to win, even if you have great testimony, it's hard to get summary judgment. But a lot of times you file it strategically. And if the client signs off on spending the money to, for lack of a better description, educate the court for the trial that may come down the road if you lose, well worth it in the right case. And you want to seem credible. So you don't want to make it seem like you're hiding half a sentence or half a paragraph. So I tend to use block quotes, so they're indented on both sides, to really sort of dispel any notion that I'm truly cherry picking within the words that a witness has given me. But I like to then say, either in the filing itself, in a footnote, I'm kind of a big footnote guy. I know people go back and forth on that. So I'm not going to take a stand on that for this purpose today. But a lot of times I'll say, usually in a footnote, the transcripts, the full transcripts are available if the court wishes to have them, if their standing order doesn't say. And that way, I want to tell them, here's the quote that matters to me, or that should matter to you, judge or clerk. But I've got the whole transcript and I'm not afraid to give it to you. That way, you're kind of getting the best of both worlds. But I hate filings that, I mean, I'm holding my hands up from the days that we used paper, which is a joke. But I don't want a multiple gigabyte file to go to the clerk unless they really want that. So I'll make it available. I'll tell them it's there, but here's what I want you to focus on, and that'll be in the brief.
Yeah, and I think you just kind of said to me, what's the key word in all this is focus. What are you trying to get the decision maker to focus on? What's the best way of going about that? And a similar side of this coin that you already touched on, Rich, is something I wanted to direct to Matt as well. We're talking a little bit, Matt, about quotes, what to quote, what not to quote. Do you have some thoughts on that you'd be willing to share? A witness's own words can be effective in communicating what the witness is saying, but how do you decide what you're going to put in front of the court or the tribunal in terms of quoting from the witness's testimony versus summarizing it?
I'll say the same thing Richard just did, which is if it's something I want the court to focus on, if it's something I want the court to quote in its written opinion, I'm quoting it in my brief, right? You go back to the nugget discussion. If it's important enough to be a nugget that I think supports my summary judgment motion, I may quote that, whatever the nugget is. And maybe in the deposition itself, I'm listening attentively enough and following up enough that I hear that little nugget, and maybe it's not quite a nugget, it's still just like a little gold flake, right? And so I ask a follow-up question, and I'm turning that little tiny gold flake into a big fat gold bar that I can then put in my brief, right? I'm rephrasing that guy's answer the way I want it to be. So I understand you're saying you totally intended to defraud this person, right? And if you do it right, that your question becomes the nugget that they inevitably say yes to. And so if you don't have nuggets like that, then you're much more just sort of summarizing what the testimony is. I mean, realistically, if you don't have nuggets, there may not even be any cite to the deposition in the summary judgment at all. So, but it's you want the court to focus on the important stuff, and ideally get the court citing that thing back to you in whatever decision they adopt.
And I think the theme we're seeing come out here is really getting the court to engage with the material that we as the lawyer may be very familiar with, and the court may not be as familiar with. And so I appreciate both your thoughts on that. Max, this question is for you, and it's in the same area of using the deposition testimony in the context of a motion for summary judgment. Can you speak to how evidentiary rules affect the admissibility of deposition testimony at summary judgment, and whether that's something people need to be mindful of when they're putting together a motion?
So it is certainly something that people need to be mindful of. I think this is my first opportunity to use the very lawyerly answer of "it depends." And so I will say it does depend. One of the things it will depend on are the rules and the evidentiary standards wherever you may be. So most commonly, what I have seen is that yes, that in general, the rules of evidence apply. So you cannot rely on hearsay necessarily to prove something or to disprove something. So you can't have a witness who says, well, Bob told me that Sheila said that the light was green necessarily. But you can likely rely on something that you might not have a full foundation laid for to actually get into evidence, because the court will assume that if this case were to go to trial, you would be able to lay the foundation. So let's say you have something that looks an awful lot like a business record, but you have not called the evidentiary custodian, pardon me, you have not deposed the custodian of records to necessarily lay all of the foundation for that business record qualification. Many courts will say, okay, I can look at this, I can assess its likelihood as a business record, its likelihood to be admissible at trial where every I has been dotted and every T has been crossed, and I will consider it for those, based on that, for purposes of summary judgment, and determine it would likely be admissible, and I will consider it substantively. So these are the kinds of things you've got to weigh and figure out. And you will then likely see your opponent trying to argue that some of the stuff that you're submitting is not admissible. And so you should be prepared to defend it. I will say, here again, you should be very cognizant of the judges or the locality's rules. Here in the Northern District of Illinois, just about every summary judgment motion has a just about every summary judgment opinion has a footnote in it that says about how the courts disfavor motions to strike and instead consider the admissibility of those things in the merits and in the briefing. So if you see something your opponent is trying to get in that you know shouldn't get in, and you think, all right, I've got a motion to strike, most likely you have a footnote you should add to your statement of facts or to your brief, arguing why that evidence is not admissible, and you should not be filing that motion to strike that you're thinking you have.
And Max, you said something that really kind of piqued my interest in terms of local rules and in our home jurisdiction, the Northern District of Illinois. And this is going to end up as a question for Rich, but I want to allude to it. One thing we're familiar with in the Northern District of Illinois is having to file very voluminous statements of fact in support of an opposition to motions for summary judgment. That's a requirement we have here in this court. Other courts have different requirements. Some don't have a requirement and leave it to the lawyer to decide how best to present whatever the facts may be. Rich, this is a question for you on that general topic. Which format do you think is the most effective for presenting deposition testimony to the court in an MSJ? Is it different statements of fact? Is it a narrative? Is it some hybrid? Curious to hear your thoughts on that item.
Well, now that the Pandora's box of "it depends" has been opened up, and that is flying through the air right now, it depends. I wouldn't have been the first one to say that, but I'm thrilled that somebody else did. In case you haven't figured this out in 49 minutes of spending time with me today, I think in paragraphs and I speak in paragraphs. So, with that said, left to my own devices, which it isn't always my choice. It's not always my own devices, it's the court's devices. I tend to like narratives. That said, I'm very hands-on with getting client feedback on my briefs that I write before I file them. And a lot of times clients will say, not shorten up your paragraph, but pull one of the sentences in that paragraph out for emphasis or for something. So I understand the importance of changing it up a little bit throughout, because you just like silence in the face of a wall of words, silence is huge. Same thing in the face of a wall paragraph, a one sentence paragraph for that one point may make a difference. That said, I'm stuck in the Northern District of Illinois, and I don't mean that in a bad way. It's where I've practiced my whole career, so I'm used to local rules about that stuff. And you get used to the fact that some judges, some courts, some clerks require you to do sentence by sentence, bulletproof by bullet. And by then, you cite each one of those sentences. And apologize, I don't know if you hear any feedback. I'm getting a call on my office line. I apologize. So yeah, I'll do it if I have to. In general, I tend to, if it's a state court brief that doesn't require it, I'll make it more of a narrative. But that's just personal style.
All points well taken and well stated. And I think, the message here for the audience is look at the rules, but you want to be thoughtful in how you present the information, if given some discretion to give it to the court in a way the court is going to be able to understand it. And that's kind of leading into our last question on this topic of presenting an emotion. This is a question for you, Matt. Curious what your thoughts are on attaching an actual audiovisual clip of deposition testimony to a motion for summary judgment. Is that something you've had any experience with? Do you have thoughts on whether it's a good thing or a bad thing? The floor is yours in terms of walking us through your thought process on that.
So I'm going to open the floor to the other two because I've never actually attached a video or audio clip of a deposition testimony to a summary judgment motion. I think that sort of audio visual thing, you got to look at the court and the judge and the who you're presenting the motion to. And for deposition testimony, I think nearly every judge in the country would view it weird to have a deposition testimony presented by video. I think for trial purposes, having a video of a deposition testimony that you can use to impeach somebody is great. But for a deposition that goes to the judge, I don't think I would ever use an audiovisual clip of a deposition testimony. There may be times where I've got other audiovisual stuff that maybe wasn't exhibited at the deposition that I want to present as part of summary judgment motion, but not the deposition itself. But I'm interested if either of the other two have ever done that.
Never
Yeah,
touch
happy
myself.
to turn it over.
Nor would I want to. Yeah.
Yeah, I would echo the agreement, and the way I would describe it is actually whenever I find a news story and they want to present me with the video of the news story versus reading the news story, I always want to read the news story because I can read it faster than I can listen to it. And if I'm a busy judge and I have the option of playing deposition testimony, which candidly is often stultifyingly slow and boring, versus reading it, I am definitely going to want to read it because I can get through all of the ums and the pauses and everything else a whole lot faster than I think I would be able to if I was trying to watch it.
That is an interesting point. A bad video clip can go on like a bad movie, and sometimes it's easier to fast forward with your eyes than it is to fast forward with your mouse. So that's a good point. That's a good point.
And that point makes me think too that of maybe a time where I would want to use that video, a transcript where you ask a question, the next line, the answer is no. You ask a question, the next line is no. There may have been a 5-minute pause between the question and the answer that everyone in the room knows that person is trying to figure out a way not to answer this question.
Yeah.
And so if that's the impression that the witness is giving is that they're totally making up whatever answer is every single time, then maybe I do want to attach that video because that's going to have more of an impact on the judge than just reading the paper transcript where it looks like they answered, you can't tell the time frames in there.
And I would just add basically what you just described, Matt, was kind of what I had been thinking about when we were talking about how much to quote and how much to cite deposition transcripts and those kinds of things.
Mhm.
You want to tell the judge what's coming and then prove it. And every time you tell the judge what's coming, you want to be sure you can prove it. And so I want to say the witness, after a long pause, answered no. See this clip to see that long pause. And the idea here is, Judge, if you really need to verify what I'm telling you, here's how you can go verify it. But really, hopefully, by the time the judge gets most of the way through your fact section, they've learned, because you've been consistent in delivering, when you cite something, it is going to say what you said it said. And so hopefully through your advocacy and through your presentation, you're building up your credibility with both your briefing and your citations. And that's going to allow you to convince the judge at the end of the day that, yes, I don't have, even though I have the large stack of paper that Rich referenced earlier, or the many gigabytes, I don't actually have to go hunting through them all.
And I'll ask a question now to kind of tie together defending against summary judgment. I think it unifies the two topics. And Max, I'll put the question to you. Do you have any rule of thumb, even a general one, on the sort of considerations that go into how much testimony or how little testimony you should be given to the court? What's too much? What's too little? What are some factors that go into that?
So this is another one that's going to vary a lot depending on the case and depending on the circumstances. In an ideal world, you will give the judge, particularly if you are seeking summary judgment. So remember, you are saying there are no material issues of fact. So you want to give the judge as few pieces of evidence as possible to establish what you need to establish to prove your case. So hopefully, if you're moving for summary judgment, you have clear testimony that proves the elements of your case, and you want to give the judge just enough to prove those elements. And then on the flip side, if you're defending against that same motion, you want to say, hang on, judge, this is only a very, very small part of the story here. You've got to look at all these other things. And so, if you're defending a motion for summary judgment and you have very little evidence on your side, that feels like you have a problem. And it feels like you've already presented a paradigm in which the other side, which is seeking summary judgment, has an advantage because it's your job to show material issues of fact. And if you can't do that, maybe you can do that with a very little bit of evidence, in which case, great. But most of the time, you're going to want to. So I guess what I'm really saying is, if you're moving for summary judgment, I would say err on the side of caution and don't give too much. If you're defending against summary judgment, err on the side of over-inclusion and give as much as you can, in hopes that one of those pieces one or more of those is what gets stuck in the craw of the judge and prevents summary judgment.
It's a good balance to strike, a challenging balance to strike. I guess that's the art of advocacy there. We're approaching the end of our hour. I think we've got time for one more topic, and I'll direct this one to Rich. And it's kind of the flip side of what Max was talking about when you're defending against the motion for summary judgment. What do you do if you suddenly realize you didn't get certain discovery that you think you need to defend against the motion, and you're kind of stuck in a procedural bind? Can you speak to that in our remaining couple minutes, Rich, and give us some thoughts on it?
Sure. First thing, don't be in that position. Let's start there. But if I'm going with your hypothetical set and you're there, oh well. Rule 56D does allow you to submit in a declaration form that you were unable to present certain facts to support or justify your opposition. And so all is not lost is the bottom line. You have to do it thoughtfully. You don't want to do it by saying, "Oh, shoot, I forgot. I'll fall on your sword." That's not going to get you anywhere. But there are those times where something came up, in the last of the depositions that is an oh boy moment or an oh shoot moment. And so you do what you can to be as nimble as you can by declaration. You don't want to make those sorts of declarations. You don't want to try and do too much. You want to do as little as possible to demonstrate to the court that this is a discrete point here. And I'm not asking you through a witness that nobody's ever seen or talked to before to rethink everything. But on point A, B, and C, and only point A, B, and C, in fairness to the process, and I think you want to couch it that, yeah, it's fairness to you and your client, but fairness to the truth seeking of the process. This is what you need to see, Judge, and when you see it, you'll understand why. And I think you work with that as best you can.
No, excellent way to put it. Keep it narrow and relate it to the case in a way that doesn't suggest you're reopening all of discovery for the years and years that was already underway. I want to thank everybody for the time. You all were really engaging and appreciate that. Thanks to the audience for sticking with us, and we really appreciate everyone's participation. So I think that's a wrap for the afternoon, and much appreciated.
Thank you.
Thank you.